Hello, I'm here to educate rideshare and gig workers on their rights regarding the FAA, arbitration, and non-lawyer representation. Most rideshare and gig workers are shocked when their account is deactivated. What follows is confusion, fear, and silence. You are told, you cannot go to court. Your dispute must go to arbitration. This decision is final. None of that means you have no rights. To understand your rights, you must understand 1. The Federal Arbitration Act. 2. What arbitration really is. 3. What happens after deactivation. 4. Your right to a neutral arbitrator. 5. Why non-lawyer representation is allowed in arbitration. Part 1. What is the Federal Arbitration Act? What the FAA is. The Federal Arbitration Act, found at 9 U.S.C. Sections 1 through 16, is a federal law passed in 1925. Its purpose is simple: to enforce arbitration agreements fairly and ensure disputes are resolved without court delay, but with due process. What the FAA does not do. The FAA crossmark does not eliminate your rights. Crossmark does not give companies unchecked power. Crossmark does not remove fairness requirements. Crossmark does not require you to have a lawyer. Crossmark does not allow biased or broken arbitration. Part 2. Why rideshare contracts use arbitration. Most gig contracts include mandatory arbitration clauses, waivers of jury trials, requirements to resolve disputes privately. This is legal only if arbitration is fair, the process works, the arbitrator is neutral. If arbitration becomes unfair, the FAA provides remedies. Part 3. What arbitration actually is. Arbitration is a private dispute resolution process, less formal than court, focused on facts, procedure, and fairness, governed by the FAA, controlled by the arbitrator. Arbitration is not a courtroom, a criminal proceeding, a place where lawyers are required, a system where one side controls everything. Part 4. What happens when your account is deactivated? When a worker is deactivated, the company has already acted, there was usually no hearing, evidence is often hidden, the worker is left to react. The FAA recognizes this imbalance. That is why arbitration requires notice of allegations, opportunity to respond, neutral decision makers, fair procedures. These are due process principles. Part 5. The right to a neutral arbitrator. FAA Section 5. Appointment of arbitrators. Under 9 U.S.C. Section 5. If the arbitrator selection process fails, there is a deadlock, the chosen forum will not act, the process becomes unfair. Backhand index pointing right: a court may appoint a neutral arbitrator. This is not optional. The statute says the court shall appoint one. Why this matters? This prevents stacked arbitrator pools, delay tactics, repeat player advantage, one-sided control. Part 6. Why going to court does not mean litigating. Workers often misunderstand this. You do not go to court to argue your entire case, demand reinstatement, sue the company. You go to court to compel arbitration to proceed, request a neutral arbitrator. Once that happens, the case returns to arbitration. Part 7. Non-lawyer representation in arbitration. This is one of the most misunderstood issues. Key legal truth: arbitration is not a court of law. Because of this, the FAA does not require lawyers. Most arbitration rules allow any representative. Arbitrators control representation. This is common in labor arbitration, employment arbitration, consumer arbitration, international arbitration. Part 8. What the law allows non-lawyer advocates to do. A non-lawyer advocate may help prepare arbitration filings, organize evidence, explain procedures, present factual arguments, raise procedural fairness issues, appear in arbitration if the arbitrator allows. This is advocacy, not practicing law. Part 9. What non-lawyer advocates cannot do. To stay lawful, non-lawyer advocates must not claim to be lawyers, give legal advice, represent clients in court, file lawsuits, provide legal opinions. Clear disclosure is required. Part 10. Why companies dislike non-lawyer advocacy. Because non-lawyer advocacy educates workers, exposes procedural abuse, forces transparency, reduces intimidation, levels the playing field. This is why pressure tactics exist, not because it is illegal. Part 11. Due process inside arbitration. Due process in arbitration means knowing the allegation, seeing the evidence, having time to respond, access to relevant records, a neutral decision maker. If these are denied, the worker may raise procedural objections, file motions in arbitration, preserve the record for review. Part 12, where non-lawyer advocacy fits. A non-lawyer advocacy organization supports the worker, helps them navigate complexity, prevents procedural silence, improves fairness, keeps the process accessible. Part 13, full legal disclosure. Non-lawyer advocacy organizations are not law firms, do not provide legal advice, and do not represent clients in court. Their services are limited to education, procedural support, and advocacy in arbitration, subject to arbitrator approval and client authorization. Conclusion: the big idea. Arbitration does not mean you lose, you are silent, you are powerless, you must face the system alone. The FAA exists to enforce arbitration agreements fairly, protect neutrality, preserve due process, allow flexible representation. Knowledge is power. Process is protection. Fairness is enforceable. Final takeaway for drivers. Read your arbitration clause. Know your FAA rights. Demand neutrality. Do not fear arbitration. Seek education and procedural support. Understand that non-lawyer advocacy is lawful in arbitration.